Jeff Thompson with Costangi, Brooks & Smith is going to be our presenter. Jeff is the managing member of Costangi, Brooks & Smith in their Macon office. Costangi, Brooks & Smith is one of the largest labor and employment firms in the country and has over 20 offices with 2 in Georgia, both Atlanta and Macon. Jeff has been in practice for over 20 years and specializes in labor and employment law within the healthcare industry. In doing so, Jeff provides proactive advice in litigation defense of discrimination charges, wage and hour investigations, FMLA claims, and assists in developing union avoidance programs. Jeff recently has been appointed by Georgia's Attorney General to be a Special Assistant Attorney General and serves on the Board of Directors for the Georgia Employers Association and the Society for Human Resource Management. So in just a moment, I'm going to turn it over to Jeff, but just want to let everyone know that all participants are muted at this time, but if time allows, towards the end of the hour, we will unmute and have time for questions at that point. So thanks again for joining us, and Jeff, I'm going to turn it over to you.
Very good. Well, thank you for having me today, and we'll get set up here and go through the process. Folks, I'm delighted to be here today and talk to you about this issue of health care. As you know, this has been a hot topic and a very contentious topic for a period of time. One of our specialties is healthcare law as it involves employees. That is ERISA and that type of work, and so that's the reason why we get involved in these processes, because it involves your employees. What I'd like to do today, and what's kind of our agenda items, is I want to take you through an outline. First, a little history lesson on how we got here on this Protection Act. And what I call it is PACA. It's called the Patient Protection and Affordable Care Act, but I call it PACA. We're going to talk a little bit about a timeline. We're going to have a little discussion about how it is proceeded, and we're going to talk about some roadblocks, and then obviously discuss the main topic, which was how it's going to affect small business. I want to begin by talking to you about and giving you a little bit of a history lesson on PACA. As you know, it's still making front page news. It was introduced March 23rd of 2010, and it was a combination of the Patient Protection and Affordable Care Act and signed in as the Reconciliation Act on March 30th of 2010. And both of these were combined to what we call healthcare reform. And obviously, during that process, as you know, there was a lot of fighting that was going on as a result. I'll tell you a little cute story. I've got an 11-year-old son, and I, like a lot of Americans, was not pleased with the process that this was going through and how it was implemented. And so my son told somebody recently that I spent a lot of time yelling at the television during this process, but it is what it is, and right now it's at least a portion of it is current law that we're going to have to get prepared for, no matter where you stand on it. Let's talk first about the purported goals of PACA. The purported goals are to improve the quality and efficiency of health care, improve public health overall, increase wellness programs. There's an attempt with this law to reform the health insurance market, and the other purported goal is to encourage employers to offer the health care option to employees. Now, folks, the best way I know to explain this is to let it build on itself. And if you remember high school or college algebra, you'll remember that it all builds on itself. So if you'll stay with me for the next few minutes, I want to just take you through how this animal was grown out of the ground. What happened was the powers that be were sitting around the conference tables, and they were trying to determine how can we reform health care. And they said, we want to increase participation in health care. How can we reform it? And the idea was that we need to have a certain standard of benefits that should be offered. If we're going to bring health care out of the ground, health care legislation out of the ground, we want individuals in the country to be guaranteed certain benefits. And they deemed those essential health benefits. They said you ought to be able to have ambulatory care, emergency services, hospitalization, maternity, mental, behavioral, etc. and you see the list that I have there. And they said, so if we're going to have any type of plan, any type of required plan, then we think that any plan should at a minimum contain what we call essential health benefits. And so they listed those out. Then they said, we're going to take these essential health benefits and we're going to package it up. And they literally call it the essential health benefits package. That provides the essential health benefits. According to the Obama administration, it limits cost sharing. And what they wanted to do with this legislation is have different levels of coverage that employers could offer. And they literally, what they envisioned was this, that one of these days you walk into your doctor's office and you have a card, and you pull the card out and you say, well, I'm on the bronze plan, or I'm on the silver plan, the gold plan, or the platinum level plan. And immediately the doctor's office will know what's covered and what coverage levels there are. Once they develop these essential health benefits and place them in an essential health benefits package, if you meet all the qualifications of this essential health benefits package, then you have an approved plan and moving forward as an employer. Now, they knew that it would be a disaster to try to bring this up and make all of these changes within 1 year. So they said, well, we'll phase it in over a period of time, and that's what they have begun doing. And it started September of last year, or the newest plan year for your plan. So some of you didn't re-up on a new plan until 2011. So it began applying to you in 2011 with the new plan. And what it said was initially, well, we want to eliminate the ability for insurers to have lifetime limits. They wanted to prohibit insurers from dropping coverage, prohibit the denial of coverage due to pre-existing conditions for children, and that will phase in for adults later. And then they wanted to require dependent care coverage up to age 26, even if the individual is not a dependent. So you literally can have, let's say you have a child who is 24 years of age. They're not living with you. They're living someplace else. They may have a job, but it's a part-time job that doesn't offer coverage. Now they can be placed on your coverage as if you're the parent and you have a health plan. All right, 2011, prescription drugs. They said only prescribed drugs will be qualified medical expenses under flexible spending accounts, health reimbursement arrangements, or health savings accounts. Now, folks, the bottom line is they wanted to do this in order to raise taxes. So a lot of this stuff would have been tax exempt. It's no longer that way, and it allows them to raise taxes. Also, reporting health care coverage costs on the W-2s is now going to be required. That is, employers will be required to disclose the value of the benefit provided by the employer for each employee, and it will come out on their W-2 forms. Okay, for 2012, they are developing, and when I say they, I mean the government is developing what they call integrated health systems. Now, and they're drafting regulations on this as we speak. The idea is to get physicians from different practice groups in different specialties to work together in order to streamline health care. And the way that they intend to do it through the PACA is to basically say, okay, for a heart issue, we're going to pay, and if you have to have a heart bypass, we're going to pay a particular prescribed amount. And then it's going to be spread out, depending on how they form it, spread out over these different practices. So they're going to expect the practices to begin working together, which is going to be an interesting process, folks, to see. I work with a lot of hospitals and a lot of doctors, and that's going to be an interesting thing to watch, how they're able to bring that together. Okay, 2014. Folks, 2014 is when it really comes out of the ground, and the idea was to what they call the play or pay. employer mandate. The aim is to encourage, and I put that in quotes, encourage employers to offer group health plans. And if you don't, then and you have at least 51 employees or full-time equivalent employees, then you can be receive a penalty tax if, in fact, you don't offer benefits. Employers can offer insurance, that is, pay to help finance subsidies or those without access to affordable coverage. Now, I'll explain to you what that means in just a moment. Okay, further, or pay. The employer mandate, the employers really have a choice. The offered coverage must provide coverage that is qualifying coverage, and that's what I talked to you about earlier. That is, the essential health benefits rolled up in the essential health benefits package, and pay at least 60% of the cost, or pay the lesser of $3,000 for each employee receiving a premium credit, and I'll go into some detail about that in just a few moments, or $2,000 for each full-time employee. Now, with the $2,000 per employee, you don't count the first 30. So if you had, let's say, 100 employees, you decided not to offer health coverage, you would exclude the first 30. You would pay $2,000 per employee for the other 70, so it would be $140,000 a year. And I'll give you some other calculations in just a few minutes. Okay, employers with 50 or fewer employees are exempt from PACA. So they don't have to offer the coverage if they're under the or 50 or fewer. Okay, let's talk about some what I call roadblocks, speed bumps, and other issues that are coming up. As all of you know that are online, there was a lot of backlash as a result of this legislation. A lot that left a bad taste in a lot of people's mouths, and so they've begun to fight back. First thing was what I call the federal legislative initiative. In February of this year, the congressional Republicans voted to block the funding needed to implement PACA. Now, so far, that's they're still fighting it out. That's not going to work completely because, as I'm sure all of you know on here, the Republicans control just a third of the government, really one-half of one-third of the government. So I don't expect this to last, but that's what they've initially done. There's also been some state initiatives. Many of the governors are refusing some of the federal funds that are accompanying PACA compliance. In other words, they're saying, keep your money, we're not going to comply with it, we want to opt out of it. And also, as I'm sure all of you know on here, a number of the attorney generals were instructed by the governors to challenge the various provisions of PACA, and that in fact has occurred. Some of the other state initiatives, Maine, for instance, has received a waiver for the individual mandate provision, and 3 other states, at least as of now, New Hampshire, Kentucky, and Nevada, have also asked for an exemption from the provision. We expect more states to be doing that as well. And obviously, we don't think this is going to be resolved until it hits the Supreme Court, and it may be heard as early as next spring. So we will see. All right, I thought it might be interesting to show you a map of some of what's been going on. And this shows you legislation that's been adopted on the health care, others legislation filed, alternative legislation. You can see a number of states have gotten energized and are fighting back against this legislation. Also, and most of you probably read, this is hot off the presses, August the 12th. Which was last week, the 11th Circuit, which is the federal courts are broken up into different circuits, and they have appeals courts. The 11th Circuit covers this part of the world. It covers Georgia, Alabama, and Florida. Florida led the challenge along with 25 other states to try to find that the legislation was unconstitutional. The court just struck down the individual mandate in a 2-to-1 decision against Obama, what we call Obamacare. And you can see there the other states that were involved. And I'm going to take just a couple of minutes. I don't want to get us too deep in the weeds on constitutional law and how this process works, but I thought it might be helpful for me to explain a little bit about it. First, let's talk about the judicial process. What initially happened was an action was filed by Florida, claiming that the legislation was unconstitutional for a multitude of reasons. One of the main arguments that ended up working was that it was unconstitutional because the federal government did not have the authority to mandate individuals purchase health insurance. The government was arguing that they did through something called the Commerce Clause of the Constitution. Now, just in a nutshell, one of the ways that the federal government has been able to exert power over states and citizens of states is to argue that the individual was engaging in interstate commerce pursuant to the Commerce Clause of the Constitution. Interstate commerce can be something like this. You purchase, I'm holding a pen. Our firm purchased this pen. This pen was probably made in a foreign country. It was imported into our country in another state. It was put in a box and shipped ultimately into the state of Georgia. And then we purchased it and it was brought here. That was engaging in interstate commerce according to the federal government because we were buying products and services that crossed state lines. And as a result, they're able to latch on to individuals and exert a lot of power and authority as a result of that. And there's a multitude of cases over many years that deal with that. What happened in this case, though, was the federal government was claiming that individuals were engaging in interstate commerce simply because they engaged in living, literally living. And what the court said was, no, that's not the case, that simply making a choice not to purchase health coverage is not engaging in interstate commerce. You haven't engaged in anything by making the decision that you're not going to purchase health coverage. And so if you're not purchasing health coverage, you're not engaging in interstate commerce, and therefore the Commerce Clause does not attach. And as a result, the mandate that an individual go out and buy coverage is unconstitutional and therefore unlawful. And that's what the 11th Circuit has done. Now, folks, the reason why that is huge is because it was the individual mandate, that is the requirement that everybody purchase insurance that was supposedly going to pay for pay for PACA or Obamacare. If the individual mandate remains struck down, then those that claim to be the experts on this are saying that it will collapse all of health care related to this PACA, and therefore make it unworkable. Now, what happens next? It goes to the Supreme Court because another circuit has said it is constitutional. So anytime that or most of the time when there's a fight among the circuit courts of appeals as to what is proper and what is not, if there's disagreement, generally the Supreme Court gets interested, and we expect them to take this case up pretty quickly. So it's going to be relying on 9 people to make a decision related to this issue. All right, let me move on. I think I've pretty well covered what I wanted to, but that's some of the quotes from the 11th Circuit. The majority, which is the 11th Circuit, it was a 2-to-1 majority. There were 3 judges that sat on this panel. It said that the government's position amounts to an argument that the mere fact that an individual's existence substantially affects interstate commerce, and therefore Congress may regulate every point of their life. Their theory affords no limiting principles with which to confine Congress's enumerated power. And what the court was really saying is, look, if they can say you're engaging in interstate commerce literally by the fact that you're born, then they can take power over anything, and they're saying that they think that goes too far. All right, let me move on. Let me talk to you about the impact on small businesses and cover some of that, and then hopefully we'll have a little time for some questions. What do these reforms mean? Well, let's talk about the player pay. Folks, if you've got over 50 employees, what that means is that you're going to have to offer health coverage, and it's going to have to meet the requirements that we talked about earlier, or you're going to be paying a penalty. And that's the bottom line. Now, again, that's assuming that that when the player pay comes into effect in 2014, that Obamacare still exists. Right now, it's the law of the land, and we're having to live by it. But it obviously would depend on the Supreme Court decision. And we talked about the purposes of player pay. They wanted to broaden employer-sponsored coverage. They wanted to maintain employer coverage and minimize disruption of those who are currently insured. They wanted to increase coverage for employees of small businesses, and they wanted to provide what they call non-governmental financing for new coverage. All right, who's playing and who's paying? Workers must receive part of their compensation in the form of employer-sponsored health insurance. That's assuming that you have over 50 employees. So the play part is the employer contributions toward insurance, but funds in actuality come from the worker's wages. As you well know, when you hire somebody, you have to determine what you're going to pay them, but you also have to determine what their benefits are going to be, and that's a cost to any small employer. And some simply can't afford it. They simply can't afford these particularly health care. The government also is going to, and as part of this package, has something called free choice vouchers, and it becomes effective 2014. And that's where employers that offer group health coverage would be required to provide vouchers to employees that make less than 400% of the poverty level, which is $43,000 a year. So if they're making less than $43,000 a year, and if their share of the premium that the employees having to pay exceeds 8%, then employers would be required to provide what they call free choice vouchers, which would allow the employee to take that money, go out onto the open market, and try to purchase it out on the open market at a lesser of a price than what they would be having to pay through the employer. And I'll talk a little bit more about where they would be purchasing this in just a moment. By the way, you'll notice on the slide it says whose share of the total premium exceeds 8%, but not less than 9.8%. They're saying that there's no way that in their mind that it would exceed 9.8%, and that's the reason why they put that in there. That makes no sense to me, but that's the rationale behind that language. Okay, as I mentioned, the voucher amount must equal what the employer would have otherwise paid to provide coverage under the plan. So whatever the employer's having to pay, they would issue the voucher instead to the employee. The employee would go out onto the open market and use that in order to purchase health coverage. Let me give you some what I call play and pay tax scenarios, because you're going to see, and you've probably already figured this out, what is going on kind of behind the scenes. Let me give you a typical example of a small employee. Let's take company TUV. They pay $600,000 a year to cover their 55 full-time employees. TUV decides to drop its coverage and offer no coverage whatsoever. If they do, they're going to be assessed $2,000 per every employee after the first 30. So you'd take 55 employees, you'd subtract 30, that equals 25, and then the employer would have to pay $2,000 per employee times the 25. That's the tax penalty. So they literally would pay $50,000 a year versus having to pay $600,000 a year for health care coverage. Now, when you look at that, you say, well, you can see where the government's headed with this. As you may recall, they wanted to require more to this than was allowed. In other words, they wanted to have the federal government set up insurance, and there was a lot of pushback. So as a result, they said, okay, well, we'll offer state plans. We'll allow the states to do that. But they created formulas that will incentivize employers, quite frankly, to drop coverage and encourage employees to go into these state plans. Ultimately, and you've probably thought about this as well. Ultimately, it could end up being a single-payer system as a result. So you can see the incentive for them to do that. Let me give you another one, and I'm going to try not to confuse you, but there's going to be a lot of employers that are on the bubble with regard to the number of employees that they have. For instance, let's take this company, XYZ. They've got 48 full-time employees, but they've got 3 part-time employees that work 20 hours a week, and another 3 part-time employees that work 10 hours a week. And the question is, well, do you count, how do you count for purposes of determining whether they've got over 50 employees? And what the legislation says is it is over 50 full-time equivalents. A full-time employee under this statute is considered an employee that works at least 30 hours a week. So if you were making the determination, what you would do is you would say the 3 employees at 20 hours work a total of 240 hours in a month. The other 3 employees that work 10 hours a week, they work 120 hours a month for a total of 360 hours for those combined 6 employees. You take 360, you divide it by 120, and the reason why you come up with 120 is that's a full-time employee working at least 30 hours a week for 4 weeks equals 120. That's considered a full-time equivalent for 1 month. So that's you would divide that. So XYZ has 3 full-time equivalent employees in addition to the 48 full-time employees that they already have, for a total of 51, which covers them. Now, if you were to change that up a little bit, you could see how individuals that maybe have 45 full-time employees and 6 part-time employees, they may fall under the 50 mark of full-time equivalents and therefore not be subject to this legislation. All right, one other before to try to keep from hopefully not confusing you too much. Let's take another what I call play and pay tax scenario. Company ABC fails to offer qualifying coverage to its 100 employees, 10 of whom receive a tax credit for enrolling in the state exchange. That is, they want to enroll in the state exchange, and there's a tax credit requirement as a result. After the first 30 employees are taken out of the equation, ABC owes $2,000 for each employee for a total of $140,000. So you end up, you can see where a person they pay $140,000 a year if they offered it or failed to offer it, as opposed to what could be much more for those 100 employees. All right. There are some tax credits for small businesses. Now, I'm not a tax lawyer, but I do at least want to mention those to you and recommend that you get with your CPA to discuss maybe some advantages of this. 2010 to 2013, qualifying employers can receive tax credits of up to 35% of the contribution toward health insurance premiums if the employer contributes at least 50% of the total premium cost or 50% of a benchmark premium. Now, folks, I'm not going to go into all the ins and outs because, again, I'm not a tax lawyer, but the bottom line is this. If you're offering health coverage and it's a rich enough plan, there's a chance that as a small employer, you may get this tax credit. So again, I would check with my CPA to see whether you qualify. 2014, qualifying small businesses that purchase coverage through an exchange will receive a tax credit of up to 50% of the employer's contribution toward the employee's health insurance premium if the employer contributes at least 50% of the total premium. So just want to mention those to you, and again, recommend that you get more details on that small business tax credit. The tax credit eligibility is a sliding scale to employers with fewer than 25 employees and average annual wages of less than $40,000 a year that purchase health insurance for their employees. So if you have individuals on average that make less than that, you may qualify for that credit. There's also a penalty called the excise tax for Cadillac plans. Now, I suspect that there's not a small employer that offers a Cadillac plan, but I at least need to mention it. Effective 2018, it will level a 40% tax to be paid by insurers on premium amounts for health plans where the total premiums are over $10,200 for individual or $27,500 for family plans. Now, that sounds high, but folks, as you know, health costs are going up year to year, and they did not incorporate a provision that allows for this amount to increase as well. So that, I suspect that was done on purpose, but they may have to amend that portion of it. All right. The next thing this law does is establish over a period of time something called insurance exchanges. As you know, as I mentioned to you earlier, President Obama really wanted a single-payer system. That's what he talked about. That's what he campaigned about. And a single-payer system is where basically the federal government has one plan that is offered to everybody, and everybody pays into the plan. They call it single-payer. When they got a lot of pushback related to that, they said, okay, well, let's develop what we call state-based insurance exchanges. And that's a way to provide more organized and competitive marketplace for consumers to purchase health care, but still get around this single-payer issue that was a hot potato for them. So what would happen is these insurance exchanges would offer a chance of health plan in a kind of a standardized format, and it could be offered in the individual states. So you could have, Georgia may have 2 or 3 of these state exchanges. And also there's something called shop exchanges. Folks, one of the biggest frustrations, as you well know if you're a small business owner, is to try to get coverage for your employees at an affordable cost. And if you have, 15 employees, it's hard to get affordable care. The idea of the shops is to allow small employers to group together en masse and be able to purchase insurance as if they were a large organization. And so that's the idea of that law. Now, obviously, that's still in the works. There is some changes for self-insured employers. I doubt I've got any of you that are self-insured on here, but just in case there are some changes. Also, there was an issue of whether you should grandfather your plan. So if you had a plan that you were self-insured, you had it set in stone, then you would be allowed for the first 5 years to grandfather that. That is, not have to make changes and comply with this. Most have found that that's not beneficial to do that, but they did offer that. Okay, what do the employers need to do? I mean, if I were sitting where you're sitting, and I'm a small employer, and I'm looking at this and my head's spinning, the first thing I'm going to do is I'm going to be shopping out with the insurance companies and talking to them about how specifically is this going to affect me cost-wise, and be reviewing that very information. I'm going to assess and review current health plan arrangements to weigh my various alternatives. Again, I don't think any of you can grandfather because you're probably not self-insured, but those that are, you could. We're going to have to make sure that the plans are properly amended to provide the qualifying coverage, or you're going to have to make a decision, am I going to opt out of this? And what is it going to cost me? So those are some of the things that if I were a small employer, I'm going to be having to consider. And obviously I'm going to be going and trying to consider, do I offer coverage? If I do offer coverage, at what level am I going to have to, and are we in compliance with these various provisions? Okay, the couple of things I want to leave you with. I'm fairly skeptical, quite frankly, when it comes to the government getting involved in the private sector businesses, because I see what's happened over the years. And so one of the first things I was asked myself is, well, who's going to pay for all of this, and how are we going to pay for it? Well, the answer is, folks, we're all going to pay for it. I went through, now keep in mind the legislation's over 2,000 pages, but we combed through it looking to at how they were going to pay for this. And here's just some of what we found. Medicare payroll tax is going to be increased by 0.9% for upper income, new 3.8% tax on investment for upper income, $2, it starts with $1, goes to $2 per life on all insurance policies to fund research, and I'm putting that in quotes. Excise tax on non-qualified distributions, penalties on hospitals for preventable readmissions, what they call preventable readmissions, employer player pay and mandate penalties. So you can look down the list and see that quite frankly, folks, everybody's going to be paying in this in one way, shape, or form. All right, and I always like to have just a little bit of humor. I always remember that all the provisions are who's behind the curtain, and it's quite frankly the Secretary of Health and Human Services, who, as a result of this legislation, has become one of the most powerful individuals in Washington today. Now, again, whether that stays that way is another matter. We'll just have to wait and see.